Howdy, I'm Brian Foley. I'm a criminal defense attorney in Conroe, the Woodlands, the office in Houston as well. Today we're going to be talking about punishments under the Texas Penal Code. It is Penal Code Chapter 12, and this is going to be sort of a comprehensive overview. We're not going to go into each statute. I'm going to give you the general overview, and then we're going to go in other videos into each one more closely. So let's look at 1201. Punishments in accordance with the code. A person or judge guilty of an offense under this code shall be punished in accordance with this chapter in the Code of Criminal Procedure. Basically, it just dispenses with old laws. It says penal laws enacted after the effective date of this code shall be classified for punishment purposes in accordance with this chapter. This chapter does not deprive a court of any authority conferred by law to forfeit property, dissolve a corporation, suspend. See, nobody cares about that. That's not going to be relevant for criminal law almost ever. If you have a case that's relevant for that, give me a call. We can talk about it. Classification of offenses. You've got felonies and misdemeanors in Texas, okay? In Texas, the classification of misdemeanors, you've got at the low end, Class C misdemeanors. This is like tickets, speeding tickets, a ticket for public intoxication, which is a little more serious, but it's still a Class C misdemeanor at the end of the day. You've got above that Class B misdemeanors like possession of marijuana, theft. Reckless driving is an interesting one. It's partially a Class B, but it's got a maximum punishment of 30 days instead of 180. And then the highest level are Class A misdemeanors. Almost all assaults that are filed by district attorneys are this, unless it's assault by contact, that'd be a Class C. But most Class A misdemeanors are like evading arrest, assault family member, things like that. Okay, so then let's talk about felonies. You've got capital felonies, which are death penalty eligible or mandatory life in prison. Felonies of the first degree, which have a punishment range of 5 to 99 years or life. Second degrees, 2 to 20 years or a $10,000 fine. And the $10,000 fine is applicable to first degrees as well. Felonies of the third degree, which are 2 to 10 years and up to a $10,000 fine. And state jail felonies, which are not considered full-fledged, it's hard to describe it, non-state jail felonies, like a real felony is what we would call that. A real pen trip is potential, pen meaning penitentiary. So you can't go to the penitentiary on a state jail, at least if it's not enhanced. And that's introduces the complexity of Chapter 12. Ordinary misdemeanor punishments, we went over that. Ordinary felony punishments, those are listed in here. That gets us through 1235. Okay, so let's look here. So the first thing you need to know to really understand, like if you're a lawyer watching this, that you really need to understand about Chapter 12 of the Texas Penal Code, not the Code of Criminal Procedure. This is outlined in the Penal Code. 1235, there is A, B, and C. Okay, this is called state jail felony punishment. 1235 A is your regular old state jail. Okay, except as provided by subsection C, an individual judged guilty of a state jail felony shall be punished by confinement in a state jail for any term of not more than 2 years or less than 180 days. Okay. Subsection B, in addition to confinement, an individual judged guilty of a state jail felony may be punished by a fine not to exceed $10,000, right? Okay, so the B part, that doesn't really get referenced anymore when we're talking about 1235. But let's look at subsection C. An individual judged guilty of a state jail felony shall be punished for a third degree felony if it is shown on the trial of the offense that a deadly weapon, as defined by Section 107, was used or exhibited during the commission of the offense or during immediate flight following the commission of the offense, and that the individual used or exhibited the deadly weapon or was party to the offense and knew the deadly weapon would be used or exhibited. That's C1. C2, the individual has been previously finally convicted of any felony under Section 2102 or listed in Article 42A054. And 2102 would be continuous sexual abuse of a young child or a disabled individual. And 42A054 would be our old 3G list. Remember, the Code of Criminal Procedure used to have 4212, Section 3G. That was the list of the really bad crimes. And that's what it says. If you have a state jail offense, let's say just a regular old burglary of a building, it's not a third degree felony. It's not a second. It's not a first. It's just a building. Let's say you stole a lawnmower out of somebody's shed that was not attached to their house. Okay. That would be a state jail felony, regular in its 1235A state jail felony. That's a regular state jail felony. If you did that felony and in the process or the immediate flight from the commission, you used or exhibited a deadly weapon like a firearm, or really anything that can be used to inflict deadly force, you're going to fall under Section 1235C1. And that is going to change the way this is punished. Okay. And it's going to say that it is punished as a third degree. It does not turn the offense into a third degree offense, but it does change the punishment. Okay. And we're going to see why that's really, really important when we're discussing the habitual enhancements, which is the part of the punishment code that everybody gets caught up on. And I say it's really important. It's pretty rare that you get a 1235C offense, but they can happen, right? So if you're a prosecutor out there and you're listening to this, you probably, I don't want to say probably, it depends on the training. There's some offices have really good training. Other offices not so good at training. 1235C2 says if you've got a prison trip, a final conviction, not a probation, the case isn't on appeal, but a final conviction, meaning you went to prison and you get out and then you burglarize a building. If your final conviction was for like aggravated assault with a deadly weapon or aggravated kidnapping involving a deadly weapon, or like we saw in 2102, the continuous sexual abuse of a young child, if that's the previous conviction you had and you commit a regular state jail felony, then you are going to be able to be punished as a third degree felony, and it's a 1235C state jail felony. Okay. You still have a state jail felony conviction because it says they shall be punished for a third degree felony, not convicted of. It doesn't change it. A good example of how it could have changed it to a third degree felony would be, let's say you have a theft case. It's a theft of a $25,000 necklace. Okay. So if that's the case, if you stole a $25,000 necklace from somebody who's 35 years old, then you have committed a state jail felony because it's in between the punishment range of $2,500 to $30,000, and any theft that's in that range is going to be a state jail felony. But if you stole that $25,000 necklace from somebody who was over 65, let's say they're 69 years old, that's an elderly individual. And theft from an elderly individual moves up the value ladder by one. So the value ladder being the range of punishment for depending on how much you stole, right? So $2,500 to $30,000 against an elderly person, you are not being convicted of a state jail and then enhanced to the punishment range of a third degree because they were elderly. You are being enhanced to a third degree conviction. Okay. That is going to count the same. Any third degree felony or higher is going to count the same for enhancement purposes as a 1235C enhanced state jail felony. Okay. So let's keep going. 1242, penalties for repeat and habitual felony offenders on trial for first, second, or third degree felony. Okay. In this section, this is the part where your punishment range can get increased by one level to a second degree or to a first degree, or you could get double enhanced to habitual felony offender status, where your minimum punishment is 25 years in prison or up to life in prison. Okay, so how does this happen? Well, except as provided by subsection C2, which has a bunch of different exceptions that for a general understanding of the felony enhancements you don't need to know, but we'll go over it eventually. Except as provided by subsection C2, if it is shown on the trial of a felony of the third degree that the defendant has previously been finally convicted of a felony other than a state jail felony punishable by section 1235A, on conviction, the defendant shall be punished for a felony of the second degree. Okay, that's a lot of words, and it's confusing. So what is it really saying? It's saying if the new offense that this person has committed and you're trying to punish them for, that courts are trying to punish you for, if that is a third degree felony or higher, then if you've been previously convicted of anything but a regular old state jail, then you can enhance it to a second degree. Okay. So what is it? What are the possible crimes that are not a state jail punishable under 1235A? It's everything else. It's a third degree. It's a second degree. It's a first degree. Heck, it'd even be a capital. I don't know how you're going to get out on a capital, but I suppose it's possible. In any case, it's not possible because it's life without parole. But there could be changes in the law that you could have that. In the 80s, there used to be capitals that you could get out on. So, in any case, any old regular state jail doesn't count, but everything else does. So that is the main principle that you have to understand. The difference between a 1235A regular state jail and a 1235C 1 or 2, which are the like super state jails, Okay, so then the next section here, that was subsection A of 1242. 1242 is where you're going to go for all your punishment enhancements, almost all of them. Subsection B, if you're on trial for a second degree and you got those final convictions of a felony other than a state jail felony under section 1235A, right? The regular state jail felony. As long as it's not one of those, you got a second degree, you prove they were previously convicted of a state jail 1235C 1 or 2, or a third degree, or a second degree, or a first degree. If you can prove any of that, your second degree punishment goes to first degree punishment. Okay, same thing is true. First degree punishment goes to, instead of a minimum of 5 to 99 or life, the minimum becomes 15 or 99 or life. Okay, and then you can still get a fine of up to $10,000. Then we go down. We're going to skip a few sections here because it's really confusing. We can go over those. But if you were previously convicted 2 times and sequenced, which is important, then you have what's called the habitual enhancement. So let's read the language of that. It's a little ways down. Okay, subsection D. If it is shown on the trial of a felony offense other than a state jail felony punishable under section 1235A, we know what that means, right? That the defendant has previously been finally convicted of 2 felony offenses. So 2, right? And the second previous felony conviction is for an offense that occurred, says subsequent, but right after the first previous conviction became final. Then on conviction, the defendant shall be punished by imprisonment in the Texas Department of Criminal Justice for life or any term of not more than 99 or less than 25 years. A previous conviction for a state jail felony punishable under 1235A may not be used for enhancement purposes under this subsection. Okay? So that is saying if you have a third degree or higher, or the 1235C business, and you go to prison, then you get out, then you go back to prison on another third degree or higher, or a 1235C, and then you get out, and all the appeals are done because it has to be a final conviction. And final conviction just means you went to prison, there's no pending appeal, things like that. If all that happened in sequence, meaning you had your chance to go to prison and be reformed, it didn't work. You got out, you went back to prison, had your chance to be reformed, it didn't work. And then you got this new offense. If you're convicted of the new offense and they prove all that stuff happened in the past, your punishment range is a minimum of 25 years. This is, the three strikes rule basically for Texas. And it's extremely difficult to have a case and defend a criminal case where your punishment range is 25 years as a minimum. Because any legal issue, typically there's a little bit of gray area in almost every case. There's no such thing as a perfect case for a prosecutor or a defense attorney. But there's normally some wiggle room, and there is some sense that the value that the person themselves and their life and their family and what they're doing for a job, the value that they bring can potentially earn them a probation where you don't have to send somebody to prison. But this statute requires being sent to prison for a minimum of 25 years if all of that is proved. So let's say you burgled a habitation, like a house, broke into a house, stole a guitar, pawned it when you were 18 years old. Okay, maybe you're homeless, whatever the situation is, that's what happened. You went to prison, you got like a 3-year prison sentence. Then you get out and, you end up having like a drug issue, something like that. You've got drugs in your car. The police, maybe it's just marijuana even. The police try to pull you over. You get scared. You drive off. You evade the police in a motor vehicle. That's another 3rd degree or higher felony because you've already got a felony prison trip from the deal when you're 18. You're not eligible for probation. So you end up with another felony prison trip. Okay, maybe another 2-year prison trip. Okay, then let's say you get caught with 1.5 grams of methamphetamine. Okay, that is not a first degree, but a penalty group 1 level offense. It's more than a gram, less than 4 grams. That's a 3rd degree felony on its own. You've got a prior evading motor vehicle, 3rd degree felony, and a prior burglary of a habitation, 2nd degree felony. If that's your range, you could have committed 3 crimes in your whole life, have drug related issues. You may, at this point, when you were found with the methamphetamine, you could own your own business. You could have a family. You could have lots of things going well for you, but relapse into drugs. And then bam, you could end up with a punishment range of 25 to life in prison under this law. And it's not that those things don't count when time goes on. I have people ask me this all the time. Well, isn't there like a 10-year rule, or can they really go back to like 1980 and use a prior crime that happened then? Yes, they can. There's no time limit on these. They can use them from other states as well. The defense would have to help. Your defense would be, in a case like this, see if there is sufficient evidence to prove the final convictions in the past. And then let's take a moment just to look at the idea of what is really a final conviction. Again, that means you went to jail or prison, and there's no appeal pending. The case is essentially over. So if you get shock probation, which is a case where you go to prison, but then the judge pulls you out of prison and puts you on probation, that is not a final conviction. If you get deferred probation, that's not a final conviction. If you get regular probation, not a final conviction. It used to be the case that it depended on the jurisdiction if it was from another state, but that's not true anymore either. So these are really interesting and confusing issues. Next time, we're going to talk about penalties for repeat and habitual felony offenders if the case you're on trial for is a state jail, or if it's a misdemeanor, and then reductions of punishment ranges, taking cases into consideration, and then some enhancements if it's like a hate crime. That's all under Chapter 12 as well. So we'll check that out next time. But this was the main bulk of the work for Chapter 12 of the Texas Penal Code on punishments. Thanks for watching. Don't forget to like and subscribe, and we'll see you next time.